day, everyone, and welcome to the Escobar Turns 1 False Claims Act Materiality in 2017 conference call. Today's conference is being recorded. At this time, I would like to turn the conference over to Rebecca Pearson, partner in our Venable Government Contracts Group. Please go ahead, ma'am.
I want to thank everyone for joining us in this birthday celebration for Escobar. We're so pleased as attorneys who primarily represent defendants, always represent defendants. The Supreme Court gave birth to Escobar, which significantly, as we're going to talk about, limited while it validated the fact that there is implied certification, it also restricted the circumstances in which that could be used. So we're going to get through that, and in fact, we're going to start and talk off by talking about the landscape of Civil False Claims Act, because, you know, by way of background, I came into the government contracts practice in the United States Air Force just as the Berlin Wall was coming down. And at that time, the government had realized that it had improperly treated a lot of contractors as criminals, and they saw how that really destroyed the contract practice and the entrants that were willing to come and participate in the government contracts practice. So we had basically a movement away from treating every dispute in the government as a civil false claim. And that changed about 10 years ago, I would say. And so now we've had a dramatic increase in civil false claims up until Escobar. While Escobar certainly doesn't stop the Civil False Claims Act liability, the good news is it does bring some, in my view, rationality to the process. So we're going to walk you through that background. We're going to also talk, of course, about the case itself and also the Civil False Claims Act landscape after Escobar, because Escobar answered one question and, of course, raised many new ones. And then we're going to also talk about then practically as a government contractor or in government contracts practice, what does Escobar mean for your particular practice of law? And to assist me with that is Warren Hamel. He is the chair of the Venable Investigations and White Collar Defense Practice Group, and I'd like to claim him also as a member of our Government Contracts Practice Group because he works frequently with us. Because as I mentioned earlier, you know, now Civil False Claims Act liability is something we think about every time we look and try to have a contractor understand a proposal or a solicitation or a dispute that arises throughout the contracts practice. It now is part of our life. And I've had the privilege to work with Warren on several matters, and I'm going to turn it over to Warren to introduce himself as well.
Well, thanks, Becky. I appreciate that. And believe me, I'm privileged to be a friend of government contracts practice here at Venable. It's been a great partnership. My background is more on the criminal defense side and investigation side. I was an assistant U.S. attorney for 12 years in Maryland, left the U.S. Attorney's Office in 2002, and I've been at Venable ever since. A very large part of our practice has been False Claims Act, often married to a parallel criminal investigation, which is sort of your worst case scenario, but sometimes it has to be dealt with. So I've had experience in generic pharmaceutical False Claims Act and criminal sort of parallel investigations. I worked with Becky very closely on a False Claims Act matter involving a massive DoD contract over several years. And I've done smaller ones all up and down the scale, but from my perspective, it's fraud. It's fraud that doesn't rise to a criminal level in most instances, but there's an awful lot of similarities there.
I mentioned a little bit about my background. A big part of it is, a big chunk of it is Civil False Claims Act defense, as well as compliance issues during contract administration to ensure that you don't ever get brought in to Civil False Claims Act defense. The landscape is important, though, and it's all about the money, really, because as a government contractor or someone who deals with government contractors, you have to know that every employee or former employee who's disgruntled, every team member or subcontractor and their employees that are disgruntled can all turn in to key TAM relators with the power to bring their own Civil False Claims Act for something that during contract performance a contractor might have thought was perfectly okay. Of course, we're going to get into Escobar is some of that might get pulled back in terms of if the government has knowledge and doesn't think it's material. But in terms of the money's not going away. And in fact, Warren's going to get to that in a minute because they've actually increased the per invoice, per claim penalties. So there likely will be even more money at stake here. And if you turn to the next page, you can see that from 2013 to 2016, civil false claims is bringing in a lot of money to the United States government. And the prosecutors, as good as they might be, they're not getting paid more when they win, but what they do get is they can get a really, really nice press release that has their name and how much money they save the taxpayers of the United States. So they're motivated by money too, meaning that the more money that's at issue in a case, the harder it is to get rid of it and the harder it is to sort of bring rationality into whether it's really a civil false claim.
And sometimes they get brought to D.C. where they get a nice recognition in front of Main Justice in the Great Hall, the AG's award or whatever, because some of those very big False Claims Act settlements and judgments can really get a national profile for them.
Right.
So just also thinking about my side of the house a little bit more, we do have a history now, and it's a history that indicates increasing interest on the part of DOJ to pursue criminal charges in tandem with False Claims Act suits, which obviously really increases the potential jeopardy for both the company as well as individuals, and in some ways probably more so for individuals, since individuals are the ones who might be facing jail time. But for those of us who have prosecuted or defended criminal investigations involving false statements to an agency of the United States, that's really not that far away from a false claim submitted to the United States as well. And if the government can identify individuals inside the organization who made actual decisions to submit false claims or understood that false claims were being made, did nothing to stop it, that they're going to be looking at that very closely. The Yates memo, which is referenced up there, of course, that was Sally Yates who wrote that during the Obama administration. Interesting impact on the criminal practice and in some instances on the False Claims Act practices, where essentially line assistants, the DOJ attorneys who are actually prosecuting the cases, if they do not include individuals in their charging documents, if they do not include individuals in the False Claims Act settlement, they have to write an internal memo actually justifying why. In fact, Becky and I had this on a matter out in California, where we reached an agreement in principle with an assistant U.S. attorney on a potential settlement for our corporate client. And she essentially said, I need to go away for 2 weeks and I need to write my memos telling Main Justice why I'm not going to include any individuals in this. That's a very real impact on their practice, and it sets up certainly a motivation and incentive to go after individuals. The new Attorney General, Jeff Sessions, has indicated he'd follow the Yates memo. That's something that in the criminal practice we spent a lot of time scratching our heads for a couple of months, whether they would buy into Yates, given the interesting and complex history between Sally Yates and Jeff Sessions and the Trump administration. But it looks like they will be pursuing that and continuing that. And then, as Becky mentioned, the per invoice or per claim penalties have increased from $10,781 to $21,000, effective for violations occurring after February 2nd, 2017. And as bad as finding damages, single damages, and then trebling them can be, for some particular kinds of contracts where there are tens of thousands, hundreds of thousands of actual invoices submitted, the per claim penalty can just be a staggering add-on. Sometimes it can drive the penalty even more than the actual damages itself. So, Likely to increase. Look, this is an area where there's some real return on investment for the government. I've considered in the same areas Foreign Corrupt Practices Act, where the government pursues companies. Companies feel like in many cases they can't defend and certainly don't want to take this to trial. So there's a large incentive to settle. So I don't see the False Claims Act cases going away. And of course, as Becky will talk a little bit more about, all of that needs to be sort of folded into a company's decision about whether and how it's going to do business with the federal government. So just a little quick primer, kind of looking back a year ago to Escobar itself. They say bad facts, etc. Well, I don't know whether bad facts may be a bad case or a good case, but the bad facts were what came out here. There was a teenager who was being treated by United Health Services Clinic, ultimately diagnosed with bipolar, was prescribed medicine by counselors at a UHS facility. Turns out the counselors were not what they held themselves out to be. Of the 5 who treated the teenager, only 1 was actually a doctor. And the others were essentially unlicensed and didn't have the background or requirements to prescribe these medicines. The teenager took the bipolar medicine, had a bad reaction, was hospitalized, ultimately died. And the family brought a False Claims Act case against United Health Services, essentially alleging that any of the payments, and the connection here with the government is that the treatment was paid for by Medicaid. So the allegation was that by treating this teenager with this very, very difficult mental health condition and holding themselves out to be qualified and then submitting the Medicaid for payment for that treatment, that constitutes a False Claims Act violation. The parents sued United Health Service claiming that they violated Massachusetts Medicaid regulations pertaining to staff licensing, and that therefore UHS did not comply with the payment to the government. So the Escobar decision, Justice Thomas, backed by an 8-0 Supreme Court, imposed an implied false certification theory of liability. So that answered one question, an initial question, and of course for those of you who've practiced in the area, you know that there was a split in the circuits. Prior to Escobar, at least one circuit, I believe it was the 7th, had held that there is no such thing as implied certification theory. There were a number of circuits that held there is an implied certification theory, but that they had different ways of approaching it, ranging from sort of the most aggressive and pro-government position, which is essentially any violation of a regulatory, statutory, or other or contract requirement that occurred in the course of submitting a claim to the federal government could constitute a false claim. Others had more nuanced views that there has to be some sort of materiality. So Justice Thomas wrote that liability does attach when a defendant submits a claim for payment that makes a specific representation about the goods or services provided. And here, in this instance, in Escobar, the specific representations were that when they gave services to Irushka Escobar, they included specific codes that would then prompt the payment under Medicaid for the services that were alleged to have provided. Knowingly fails to disclose noncompliance with statutory, regulatory, or contractual requirements. In other words, makes the submission, makes some representation about the actual service provided, but omits to tell other information that, and then in item 4, that would be material to the government's decision whether to pay the invoice or not. So there we have it. There is implied certification theory, and I think a lot of people felt that was the headline of Escobar, and a number of people were disappointed in that. I think my own personal view is I pretty much figured that was inevitable, and the only question was how bad was it going to be. And I think that actually, on balance, the next step that the Supreme Court took, which was to impose a very, very strong materiality requirement on those false statements or on the omissions that went with the submissions to the government. And that actually has ultimately turned out to be, I think, the bigger issue here, or the bigger factor in Escobar as it plays out. So, again, Thomas writes, liability does not depend on whether the requirements were expressly designated as conditions of payment. It's relevant but not automatically dispositive. It's a really fascinating part of the decision where there's a lot of discussions about sort of certain hypotheticals about where it might be material and where it might not be. Court disagreed with the government and First Circuit's expansive view of materiality, which is essentially any statutory, regulatory, contractual requirement might be material. And that's, I think, very positive, because that is a very difficult standard for contractors to meet. Instead, under the Supreme Court's test, it was material to the other party's course of action and has a natural tendency to influence, to be capable or of influencing the payment or receipt of money or property. Justice Thomas went on to give examples, and he gave examples pro and con. Again, so for instance, I think the example of materiality was essentially if you've got a gun manufacturer or a manufacturer of firearms for the Department of Defense, Department of Defense doesn't have to say that the firearm is capable of firing a projectile. That's what a gun is. That's what a firearm is. And so that's certainly something that, even if it's not in the terms of the contract or a regulatory requirement, most contractors would be on notice that that would be a material requirement of providing those firearms. But on the other side, the court said, so for instance, if the government pays a particular claim in full despite its actual knowledge that certain requirements were violated, that might indicate that it's not material. If the government regularly pays a particular type of claim in full despite actual knowledge that certain requirements are violated, and a signal no change in position, then that might not be material. And I think from my perspective, just from a practice, almost like a practice pointer, knowledge. It's always been a part of our practice. It's always been a part of arguing the equities in False Claims Act matters. Now I think it really gets down to what's your motion for summary judgment going to look like. And it's not just whether the government got your invoices and someone in the government knew you were omitting this information or had full knowledge of the information that's alleged to be a violation. I think discovery now is open to other contractors who are fulfilling other similar contracts. And if the government is treating them in a similar way with knowledge of similar submissions and the alleged omissions, then I think you get to use that, even if it hasn't happened in your own contract. So Becky.
Yeah, I want to just jump in here because, the biggest frustration in doing government contracts is this contract interpretation issue. And up until now, you could, government knowledge and inaction and combined with payment was a nice fact to have, but it didn't give you a defense at all. In fact, DOJ looked at it more from sort of the criminal perspective, which is, look, if you see somebody robbing a bank and you're a cop and you do nothing, that doesn't mean the crime didn't happen. You can still prosecute it. But the big difference in the government contracts is, there are hundreds and hundreds of pages that then, incorporate by reference many times standards that are themselves hundreds and hundreds of pages. And there's a lot of ambiguity. The government doesn't write perfectly. And so, but up until Escobar, government knowledge really only went to the issue of, was it false to begin with? Or were you reckless in going ahead with your interpretation? Was your interpretation reckless? But so the ability to have the government know about something and to document the government's knowledge of disputes and their inaction, that really changes not just the Civil False Claims Act practice, and we'll talk about this on the back end, but actually how, as a government contractor, you document disputes, you document issues that you think might be ambiguous, because if you can show the government has knowledge, then you just save yourself from those terrible penalties and potential damages.
Yes, and we have seen that in our own cases, time and again, time and again. All right, so just kind of in summary, SCOTUS gives and SCOTUS takes away. And in this case, they gave the government the implied certification theory, but they married it up with and stitched it right up to this very robust materiality requirement, which I think is very much a gift to the defense bar and to defense contractors, because we've already seen it in the case law, and Becky's going to talk about it in a second. The cases that have been decided since Escobar, they are being decided at the motion to summary judgment stage. Materiality is a key part of the practice now. It's a key way in which False Claims Act cases are being dismissed. So that's the bright side to it for our practice.
So I'm going to talk about, so we've just been 1 year, and it's I thought, a really well-written decision. And of course, there's now a conflict in the circuits over what that decision really meant in terms of what is that test for liability. So some courts are implying a very strict two-part test. Read Escobar, plain language of Escobar, sets out a two-part test. The first element is the claim does not merely request payment, but also make specific representations about the goods or services provided, and the defendant's failure to disclose noncompliance with material, statutory, regulatory, or contracts requirements makes those representations misleading or half-truths. And under that strict two-part test, even people like in George versus Frenzius medical care, even somebody who had that his dialysis was cut short, but they failed to show how incomplete it was, they couldn't demonstrate materiality. Now that's a case you would think, bad facts, dialysis is cut short. You would think for sure that would be material, but if you're applying this very strict test, it really, really limits the ability to, if you're a plaintiff, to succeed on an implied certification theory. But the Department of Justice didn't necessarily like that, and other circuits have broadened that test to really look at it holistically, to not have it as, it's just two elements, but really look at all the conditions. Did regulatory compliance, is it a condition of payment? How central was the requirement to the regulatory program? And, of course, did the government pay the claims once it actually knew that certain requirements were being violated? And so you see under Rose, they're saying that the focus under Escobar isn't how the condition is designated, but instead the effect of the likely or actual behavior on the recipient of the alleged misrepresentation.
So I just want to jump in real quick with a sort of a comment and a question, because it's been again noised about in the False Claims Act bar a little bit, and it may not be of much practical value for reasons that will become obvious. But one of the questions, given the emphasis in Escobar itself, is that the claim does not merely request payment, but also makes specific representations about the goods or services provided. One question that's been raised is, suppose you just have a bare request for payment. What for services rendered, which is what lawyers used to send out on their bills, or for products supplied. Would that trigger, if there were omitted conditions or omitted representations, that would that trigger this kind of liability? I think in the modern contracting environment, the likelihood that you'd be able to get away with a bare request for payment is probably pretty slim, but I'd be willing to bet somehow there are contractors that do present fairly bare bones requests for payments, and that doesn't seem to fit this particular structure that the Supreme Court set up.
Correct. So there'll be a case on that.
There will be a case on that. There will be a case on that.
And Warren, you mentioned how important summary judgment is. I think that's another big change that Escobar brings, because before then, truthfully, there wasn't a lot to have summary judgment over. Most civil false claims are pretty factually intensive. But now what we've seen is that, in fact, at least just immediately post-Escobar, their courts, they are strictly enforcing the narrower test and finding that there is really simply no dispute of fact or not sufficient so that they can go ahead and issue summary judgment on these motions. Now, some of those early ones are probably, the key TM bar didn't have Escobar before them, so their pleadings weren't perfect. And of course, anybody who's done Civil False Claims Act on the phone knows that the initial complaints that come in are terrible, and it's usually the complaints that come after that might have some nugget of what the government might get excited by or what a court might get excited by as the Civil False Claims Act.
Well, that's right. And actually, Becky, when you and I were talking about Escobar when it came out, I think we had the view that this was going to shift. It's not going to say that there would not be motions to dismiss filed, but it'd shift the emphasis in motions practice to motion for summary judgment, and that seems to have played out in the courts in the years since then. It's interesting that in Escobar itself, footnote 6, SCOTUS said yes to dispositive motions. There was some case law out there indicating that some courts had the view you simply could not decide materiality on a motion for summary judgment. It's too fact intensive, too many judgments involved that need to go to a jury. But the Supreme Court really stuck the nail on that, and so lower courts have been running with it, and it really has shifted the practice and the sort of the momentum toward summary judgment, a lot of summary judgments granted. I also have to say I agree with you. I think the plaintiff's bar is getting smarter. I think they're going to be able to draft their complaints and focus their pre-summary judgment discovery more on the issue of materiality so that they can create an issue of fact that will get them past summary judgment motions. So we'll get to an equilibrium, I'm sure, over the next year or two. And it may not be quite as pro-defense as it is right at the moment, but still, I do think that's the place where we're going to get rid of this stuff before it goes to trial.
And some of the summary judgment motions, if you look at the underlying allegations, it shows you how far the key TM relators actually had pushed the Civil False Claims Act, because they were essentially alleging that they hadn't followed the form. For example, in the Serco case, that the defendant there hadn't complied with the time charging regulations and didn't put it in the right format. There was, even though it wasn't really false in that sense, they found some little minor regulation that they didn't exactly comply with, and that was the real terror, as being somebody who represents contractors on the compliance end, is making sure, it's very difficult to sort of catch and think about all those little regulations that are embedded in the contract. And so hopefully, do you think it will reduce the number of cases that are based on really falsities that are more over form than substance, or will they just repackage it?
You have to hope that it will. I've always been interested in how the plaintiff's bar works on this, because there are an enormous number of False Claims Act matters that a whistleblower will file or try and get filed or will bring to counsel on the plaintiff's side. And as I understand it from conversations I've had with lawyers on that side, they take a very small percentage of those that come to them. So which tells me there's an awful lot of people out there who are disgruntled and would love to get on this gravy train and would love to get themselves a nice resolution and a related share. So I think that pressure is going to continue. And the question is, does the plaintiff's bar get smart about winnowing out the technical violations because they think they're not going to be successful with that, or whether it's just going to be up to us to basically hold the line when we get to litigation. One thing I would like to just mention about that, which we found in a number of cases, is if you can have some relationship with the regulatory agency lawyers, that is, in addition to the DOJ lawyers who are actually prosecuting the case, I've found, particularly the technical violations, a lot of times the legal counsel for the regulatory agency, they don't really like the technical violations. They actually despise them because what essentially they feel is that the whistleblowers and the plaintiffs' bar, by bringing these False Claims Act cases, are forcing the agencies to take regulatory positions and enforce pieces of the contract they may have no interest in regulating or enforcing. And I've seen this in FDA practice, where there's a lot of False Claims Act litigation, and there's been a recent move towards, if you're selling drugs to the VA or to Medicaid, Medicare, and your facilities are not compliant with good manufacturing processes, regulations, well, there are plenty of whistleblowers out there saying, well, then that means your drugs don't comply with regulations, and that's a false claim. But the FDA's perspective is False Claims Act is not the way to enforce GMP regulations. We have our inspectors, they go out, they tell people what to change, and that's the way this ought to work, but we are being forced by the plaintiffs' bar and forced by whistleblowers to sort of look at this and to actually deal with it in the False Claims Act environment. So if you can kind of get that notion with your regulatory counsel, is this really the hill you want to die on? Is this really the technical violation you want to make into a False Claims Act case, because it's just going to increase the flow in your direction down the road. So.
Right. Another theme that we see in some of the summary judgment motions is, if the government has done any investigation of the allegations and continues to approve the invoices afterwards, then that is a basis for summary judgment there. We've also heard some arguments that the government refusing to intervene in a case might be evidence that the government didn't find it material. What is your view on using the government's decision to intervene or not intervene in a case as some evidence of materiality?
Well, that's the perfect example of the double-edged sword. If they don't intervene, I'm going to run with it. If they do intervene, I'm going to say that's absolutely not a factor that ought to be considered, because essentially what you're doing is you're handing the litigators in the case, DOJ, the right to put their thumb on the scale as to whether this is material or not by the very decision they're making to intervene or not. To me, that's crazy. But I think we all know, because we've all been in instances where we've had a DOJ decision not to intervene, and that's been a great way to go to the judge and say, oh, Judge, see, even DOJ doesn't think it's serious. That means the agency doesn't think it's serious. We've used that argument in the past. I would hate for it to become enshrined in case law that DOJ gets to stick its thumb on the scale. I'd rather keep it as a kind of an informal argument.
Sure. And of course, the cases haven't always resulted in a determination that there's going to be summary judgment. And if you think about materiality, that is very fact-intensive, including, especially when you're looking at the government knowledge, who in the government knew? Did that person, was it within their authority to basically determine for the government that particular action or fact that's alleged to be false, was or wasn't material? Do you have any views about, what level the person has to be at within the government?
I've been not off the top of my head, although you and I had a case in which we know the contracting officer the CO was actually apprised of the issue, had multiple conversations back and forth, and took no action. Now, to me, the interesting part of that is you got government knowledge to the person who has the authority to interpret the contract and impose conditions on the contract. The question there is taking no action. Is that enough to show that they don't care? They're continuing with the contract and they're taking no action, or does that mean that the CO just got distracted and just never, it sort of fell off their plate and they never got back to it? So that might play into your earlier point. I know you're going to talk a little bit more about it. Is that is the notion of when you do have these contract disputes, trying to push them to a resolution that is very well documented, so that if it does come up later on, you're not arguing, well, of course you took no action, so therefore everything was fine.
Correct. And there was Escobar got remanded. Actually, I'm sorry. I wanted to talk about the District United States versus Galaterra versus Capital Supply. And there I thought it was interesting that they said, while materiality isn't always too fact-intensive to resolve, the standard is both rigorous and demanding. And so especially as key TAM relators are starting to get smarter in how they articulate it, it does seem to me that a lot of these cases might not be right for summary judgment, but that maybe given the materiality where it's not right for summary judgment, right now basically you couldn't get a lot of discovery in a lot of these issues. Do you think people are going to be settling less? I mean, the old tactic was you don't really want to go in front of a jury with this, but is the new tactic go and do some discovery and see what you can get from the government if you think you might have government knowledge?
Well, certainly I think, if you're thinking about your discovery plan, if this moves materiality up to the very first thing that you're going to want to try and get as much discovery on as possible, because you are going to want to use that in your motion for summary judgment. And if you don't get your summary judgment motion granted, that's going to be, one of your key arguments throughout a trial, if that's the route you choose to go to. So I do think that it will change the discovery practice as well as the summary as well as the changes we've already seen in the summary judgment practice.
Something in my world where this comes in as well is, if you're making a decision about do you have credible evidence of a civil false claim so that you have to disclose. And I'm now sort of transitioning into the mandatory disclosure rule. And just to review that for everybody on the phone, that contractors must timely disclose in writing to the agency whenever, in connection with the award, performance, or closeout of a government contract or any subcontract, it has credible evidence that a contractor's principal, employee, agent, or subcontractor of the contractor has committed, a reportable violation, which is either a criminal violation in Title 18 or essentially a violation of the Civil False Claims Act. There's another reporting requirement for significant overpayment as well, but the one I really want to focus on here is that Civil False Claims Act determination is really tough when you add an overlay of implied certification. So before Escobar, what that meant is any time you were a government contractor and you found that you had a history of regulatory noncompliance, you had to consider whether or not you had a credible evidence of a civil false claim. I still think you have to consider that, but I do think that, in that consideration and in your investigation of that, you're going to want to be able to take a look and see if there's any government knowledge of it in there, if the government's ever taken an adverse position to what they're taking now. And I think that makes it all the more important that, if you have those concerns, that you do a thorough investigation just so you understand what you have. And it may be now that contractors, if they find, strong government knowledge and approval, maybe deciding whereas before they might not have, that there's no credible evidence just based on investigation alone. So I'm going to jump into some contractor best practices on my end. This makes compliance all the more important. It's always been important, but it also shows that if you have a good compliance program and you're documenting your decisions, and you have good faith efforts to comply with all your contractual and regulatory contract provisions, part of that may be, again, it's in terms of Escobar, it's tagging the government with knowledge of how you intend to perform, what you're doing, and since the Civil False Claims Act have been very, very active, what we recommend is that people government contractors, if they know, especially if they have a practice that might be disputed or an area that might be ambiguous, they let the government know exactly what they're doing. And when we say the government, again, to your point, really only one person has authority to interpret the contract, so that would be the contracting officer. Yes, that's the same person who never picks up the phone, but they do have emails, so you can always courtesy copy the contract specialist if you're having a dialogue with the email. Review your certification process. You probably already do that as if you're a government contractor, and make sure that if you have an express certification, for sure it needs to be somebody within your company. You have good procedures to do that, and somebody within your company who is high enough within the company that they're making sure that they have good compliance procedures. You don't want to give the certification off to some low-level person who's just going to sign it and then, clock out at 5. And then I know this is tough too, but maintaining dialogue with the government customer. Because looking back after Escobar onto the cases that we've done together, I think in every big case I've done, there was some government knowledge. I mean, there is usually government knowledge, or in some cases, of course, you have a broke employee and nobody knows. But the ones that are thorny and really expensive and highly transactional tend to be also the ones where there's some government knowledge about how how the contractor's interpreting the contract and how they're performing the contract, and frankly, how the industry works as well.
Right, and I think, what's been interesting to me to see is, over a multi-year sort of complex contract relationship between a contractor and a federal agency, there's a ton of stuff that comes up, in terms of how are we executing this contract, how are we complying with the contract, and there does tend to be a lot of dialogue. And I do think that sometimes there's a tendency to say, well, we don't really want to float this issue because it's just such a pain in the neck to have to, sweat it out with the contracting officer or the contract specialist. But, the fact is that once you do that, you might not like the answer you get on the other end, but you know exactly where you stand, and it does tend to limit False Claims Act liability down the road. And that's something a lot of contractors are not thinking about. They're just thinking about, I got a contract, I got to get the shipments out, or I got to get the services done, and so they don't think in the broader, more broadly about the issue of possible False Claims Act down the road.
Right, and as somebody who works a lot with compliance, I think the smartest, most sophisticated clients think about that from the moment they get the solicitation. So right there in the question and answers, you can ask almost cross-examination type questions. And while a lot of people used to think, well, you're trying to get work from these people, why are you asking such a very pointed question? It does become necessary to, if there's an ambiguity, to clarify it. If they've got something wrong, especially if you're in a commercial industry, I think those are sometimes the most dangerous, because the government can talk like it's commercial and it can feel commercial, but the moment they think that you did something that was non-compliant with some non-commercial term or condition, they will also want to insist on full compliance with that as well. So,
and would that be an issue that is sort of made even worse by the fact that often the government doesn't understand commercial practices? They don't really understand how a lot of commercial markets work. They'd like to make use of them. They'd like to get the efficiencies out of it, but then they they think about it from their government contracting standpoint, and sort of like two worlds that don't really quite mesh. Exactly,
and I think especially when you talk about IT services providers, or even if you look at medical device companies now, they're not. They need to make sure too that they're looking at those terms and conditions on IT systems and the DFARS compliance, the cybersecurity systems. It's amazing what the DoD will try to jam into a commercial item contract for commercially available off-the-shelf items. Mm-hmm. And if you're not a contractor who's really scouring your solicitations, or even worse, sometimes the purchase orders that are coming in for very low amounts that get some of these requirements stuck into them, then you can find yourself on the back end with these terribly high penalties because it felt commercial, but then if you actually look at the contract, it's not at all commercial. So that happens from the moment of the solicitation. You can, if you think it's an issue of where the government doesn't understand the industry, you can embed it in your proposal. Pre-award is always the best time under contract theory. For good reason, a lot of people don't want to, weigh down their proposals with all the ways that the government's wrong. But sometimes, depending upon the industry, you may need to do that to make sure the government completely understands your position, so if they do award to you, then you can point that you knew all along exactly what we were doing. So that's, of course, a very fact-specific issue, but the main point is think about it throughout the life of a contract, from when it's born, and then, of course, during contract performance. Every time that there is a dispute and it's resolved, especially in your favor, that's a great thing to have people, as a matter of course, document what was said. And I know a lot of people and a lot of contractors are reluctant to try to make it feel like they're trying to document everything that the contracting officer said or the contracts people said. But it becomes really important, and what I've also found is that the government kind of gets used to that, right? If you're somebody who documents everything, then the first few times they might find it annoying or awkward, but at the end of the day, it's just more paper coming their way that they ignore. But for you as a contractor, it's really important. So I haven't seen that because I've seen all sorts of people different contractors document, and I haven't noticed that the ones that document more are less loved by their customers than the ones that don't document at all. It's all sort of how you finesse that documentation. Of course, you're going to want to also have a crisis mitigation plan if things are raised. So it needs to be, your personnel need to understand that they need to escalate those disputes up within the government contractor so that the management can deal with it, and also can think about, is this something that we need to, start a writing campaign on and document, and also push back. It's one thing if you say it in a meeting and you think they agree, but again, that becomes important that you document that agreement and what you said and what your defense is for later on. And of course, as a company, look at what is weak. If you're selling commercially available off-the-shelf items, have somebody who's at least looking at those purchase orders and seeing what the government's trying to do to you, so that the people who are doing your initial intake contract review are sensitized to what your government customers might be asking. And then, of course, you need to have a fraud awareness program and take a look at an annual basis, make sure your people are aware of how their actions might be perceived, of course, of the need to report any noncompliances that they're aware of internally throughout whatever your chain is as a government contractor, or to a hotline. Those things become really important to contractors in terms of how quickly they're able to respond and how much protection they have in a Civil False Claims Act. And I'll kind of jump in here too, because the fact that you're a great government contractor and your customer loves you won't protect you from a Civil False Claims Act, but it sure does make negotiating with the Department of Justice a lot easier. They still might. It doesn't mean that they're not going to be motivated to, allege the most amount of money possible, but what we have found is it does make a difference in terms of resolution, how likely they are to want to resolve it, to move forward. And then to give you a settlement that not only allows you to pay them money, but also, potentially protects. We talked about individual employees too. If everybody individually within the company acted properly, and it's just a dispute that they're viewing as a civil false claim, if you have good processes, I think it ends up. It probably doesn't feel like it at the time, but it does end up being a better result, easier for us as attorneys to defend.
And I agree with all that, and my particular take on the crisis mitigation, proactive assessment, and fraud awareness is, from my perspective, a key piece of all this is your internal compliance programs, and in particular, like whistleblower, hotlines, identifying potential employees through your HR department as they leave who may be in fact disgruntled or may have walked out with stuff that they might use in a qui tam. To be able to identify potential hot spots, or a lot of times in whistleblower, I've found this in one client recently, a practice changed with regard to the contract, and a number of employees felt very uncomfortable with it, and they submitted anonymous complaints in the whistleblower hotline, which prompted a little internal, like, gee, should we be doing this? Ultimately, the company decided to change that practice back. But that, it's the way that you can be out in front of the potential for a False Claims Act case, manage difficult employees as best you can on their way out. I know that's you can say that, it doesn't make it easier. But the bottom line is, as I look at it, I like to know those things in advance. I like to be able to say to the government, yes, we saw this and we immediately reacted to it. We did an investigation, and here's what we found, and here's how we changed it. And then, from Becky's perspective, you have to disclose it. You have to disclose it. But all of that is good corporate citizenship. It, I think, puts you in a much better position in terms of your contract compliance and in terms of your relationship with the agency.
I have. So while we're waiting for any questions that they might have, do you have any thoughts based on our discussion today? Any points that you think should be made that we haven't raised?
Well, I think we've covered a lot of it. I mean, it's as in all areas of litigation, it's a moving target, and I think of it's like the Supreme Court decision in Escobar has provided momentum in a certain direction. We're going to see how far that carries us. We're going to see if there's pushback and a change in the direction down the road because it's gone too far. But I do think that there are tangible, concrete things we can do. We've discussed in terms of executing the contract, complying with the contract, and then if you do get into litigation, obviously it's knowledge on the part of the government, and it's materiality in terms of discovery and focus on motion for summary judgment.
If the courts do take us down, because right now there are a significant number of summary judgments that have been granted because the plaintiffs weren't able to show materiality. Do you see any appetite for Congress to step in and clarify materiality or allow a broader standard for implied certification?
Well, I mean, that's a who knows. I mean, and who knows what this Congress is going to be doing. There's so much on their plate now, just in terms of much broader issues, infrastructure, whatever. And so whether they'll feel compelled to reach down into the bowels of the False Claims Act and try and tweak a materiality standard, I'd be surprised. Plus, I do think that Congress in general likes, when an important decision comes down like this, unless it is something that sort of shocks their conscience, like we intended for X to happen, and the Supreme Court, you've taken that away. I think they typically let it play out in the courts for several years at least, just to see where it goes. So, we'll see.
Well, let's hope so. And, I do keep waiting for the tide of the fact that every dispute is now, a potential civil false claim to turn, so that we're no longer neither the Department of Justice nor the agencies are looking at every government contractor as somebody who probably already committed a civil false claims act violation. Do you see, Allison, as a trend in that direction, or is just a course correction on implied certification, but otherwise not representative of a more significant trend?
I don't frankly see that there's going to be a huge sea change. I just think there's too much of an incentive in the plaintiff's bar and with relators, and frankly, there's too much of an incentive. We've seen it with Department of Justice lawyers and with agency lawyers. When they get their teeth into it, they see a lot of big payoff as well, even if they're not taking it home. So I think it will need to be something other than Escobar to really tamp down the False Claims Act, the level of claims. It's a good step. There's no doubt about it, but I don't think it's enough to make a huge impact overall. Okay.
Okay, with that, we don't have any more questions, so we're going to remind you that next month's Government Contracts webinar is going to be on the Service Contract Act compliance. It's going to be Wednesday, July 19th, 2017, from 12 to 1:30 p.m. You've been a great audience, and hopefully if you do think of questions that you didn't ask on the phone, please email either Warren or I. Our contact information is up there, and we'd be happy to address them.
Email, or happy to pick up the phone, happy to chat with you, and throw around any ideas or any questions you might have.
All right. Well, thank
you very much.
This concludes today's conference. We do thank you for your participation. You may now disconnect.